Why? Am I being detained? Am I being detained? Okay, then I don't need to talk to you. Have a good day. Why not? Says who? What law is that?
Why are you?
Because I can't. Am I breaking the law?
Why
What law am I breaking? Why not? Unless it's against the law, I certainly can't. This is public property, is it not? Because I can't. I'll have to give you a reason.
The officer begins with an implied expectation that the auditor will stop and engage simply because he's been addressed in uniform. But unless there is reasonable suspicion of a specific offense, that kind of interaction is typically voluntary. It's a key distinction. Authority to speak is not the same as authority to compel. WY calmly asking, "Am I detained?" The auditor removes the gray area that sometimes surrounds these encounters. That question forces clarity. If the answer is no, then the engagement remains consensual and the individual is free to walk away. It shifts the interaction from assumption to defined legal footing and prevents ambiguity from being used to create a sense of obligation where none legally exists.
You tell me I'm not breaking the law, so why do I have to stop? If there's not a judge's order and it's not against the law, why would I have to stop? Well, that's what I asked. If there's a chief judge's order or a law, that's why I asked her. She said there's no law.
I'm asking you why you reporting it.
I don't have to answer that question.
Okay, well,
That's what I'm trying to tell you. I'm asking you why. Is there a CJO? Okay, and what CJO number is that so I can look it up?
I don't have the number.
Could you call somebody?
This moment highlights a familiar problem, attempting to enforce a restriction without clearly understanding the rule behind it. When an officer relies on a specific order or regulation to limit someone's activity, they should ordinarily be able to explain what that order is and how it applies. Clear articulation is part of lawful enforcement. The auditor's calm request for the order number shifts the discussion from assertion to verification. Instead of debating opinions, it focuses on whether a concrete legal basis actually exists. When that detail can't be readily provided, it creates the impression that the restriction may be grounded more in assumption than in confirmed law.
It's the chief judge's orders that you can't be filming the facility or anywhere out front or inside.
Okay, I mean, if it's not posted anywhere and you guys don't know the actual...
Do you have identification?
I do. I'm not going to give it to you though.
What business do you have to be on the Justice Center grounds today?
I'm media.
You're what?
Media? Yeah, I'm covering getting footage for a story.
With,
Do I have to be with somebody, or can I just be an independent journalist?
are you going to stop recording?
I'm asking. Well, I mean, while you guys are making contact with me, I'm going to record that contact. But if I can't go up there and record, that's fine. I would just like to know what CJO it is so I can look it up and verify it. Otherwise, you guys just tell me I can't do it because of something that may exist or may not exist. I mean, I think it would be pretty easy to find out what that judge's order is if it's for this location. That's all I'm asking.
Right, and we're trying to figure out what story you're here for, what you need to record, what the purpose is.
What does that have to do with finding out what the chief judge's order is, what the chief justice order is?
At this stage, the focus shifts to requesting identification, which often happens when the original line of questioning doesn't gain traction. In public spaces, independent journalists generally operate under the same legal protections as mainstream media. There is usually no requirement to carry special credentials simply to film from a lawful vantage point. Declining to provide ID, where no specific legal power compels it, is a choice some auditors make to preserve privacy. However, it's important to frame this carefully. Refusing identification does not automatically imply officers intend to find something against someone. Officers may request details for various reasons, but without a statutory basis. The interaction remains voluntary. The key distinction is whether there is a lawful power engaged that requires compliance.
I won't go any further. I'll stay right here too. You know, I won't keep going. I mean, if there's a judge's order. So there's an order that says that media can't come here to take pictures.
Well, and that's what we're trying to figure out, why you're
I told
doing
you.
what you're
I mean,
doing.
I shouldn't have to explain the story. I mean, that would give away the surprise of the story and the expose. It wouldn't be an expose if I told everybody what I was recording and why I was recording.
We'll get you a number so that
Okay.
okay?
Is it the one that says no protesting, the same one that's at Elbert County? The one that
It's gonna be a
takes.
different one because they're different.
Well, the CJO that I know about is, I want to say it's 11 or -014, something -014, and that says there's no protesting, no loud noise, nothing like that, but recording isn't listed anywhere in it. And it does say that it covers Elbert County Courthouse and Douglas County Courthouse.
Here, the dynamic clearly shifts. Preparation takes the lead over intimidation. The auditor isn't just aware of his rights. He understands the officer's policy more thoroughly than they do. By referencing the specific order and highlighting that it restricts protesting, not recording, he effectively undermines their authority in this situation. This moment reveals that their original directive likely stemmed from a basic misunderstanding of the rules they were supposed to enforce.
But there's nothing about recording in
I
that
gotta
order.
get you the number. I
Okay.
don't wanna-
That might be what the order is, yeah. But I mean, if that's the order, as long as I'm not out here protesting, causing disturbance, it says nothing about filming there at all. So,
Let me get that.
Yep.
I don't
Yep.
want to misrepresent that.
okay.
As the officers scramble to check the details he's provided, the situation enters a gray zone. If he isn't free to leave, the pause effectively amounts to a detention without any clear offense. Normally, officers are expected to carry out investigations quickly, yet the auditor's calm patience lets them correct their error without escalation. Still, many would see this delay as already stretching reasonableness.
All right. They've talked to everybody, so you're free to, as long as you stay in the public area, you're free to.
Yeah, I'm not going inside the
Okay.
doors or anything else.
Yeah, that's
Thank
good.
you, guys.
All right.
And what was your name?
Knox.
Knox?
Nice to
Awesome,
meet
thank
you.
you. What was your name, sir?
Frank.
Frank? Thank you.
All right, buddy. And you are?
I'm not going to give that.
All right, buddy. That's all right.
The encounter closes with the officers reluctantly acknowledging that no law was broken. This highlights 3 key takeaways. Never feel compelled to give ID in a consensual encounter. Recognize that policy doesn't equal law, and understanding the exact rules is your best protection against mistakes or overreach. Their authority ran out the moment the law was clear. Share your thoughts in the comments. Was this poor training or a power trip? Subscribe for more accountability. This video is educational, not legal advice. Always check local laws.